Hi everyone, in this week's dispatch video we are talking about the reluctant complainant, so the person who raises a grievance or raises some concerns about the conduct of a colleague perhaps, but then doesn't want to take the matter any further. And the employer in those circumstances is put in a very difficult position because on the one hand there may be some serious wrongdoing that's going on within the organisation, and on the other hand the employee may be insistent that they do not want anything to be pushed further and have asked specifically for the matter to remain confidential. Whilst those two factors are at play, the business has to make a decision about what to do for the best, and ultimately it will often come down to the protection that the business needs to try and afford itself, which will push the employer into undertaking an investigation irrespective of any concerns raised by the complainant themselves. And this is because if the employer fails to investigate, that could open up a whole can of worms essentially, and a lot of risk for the business going forwards, not just in terms of the complainant but also from other individuals within the business. If we look at discrimination and harassment claims, for example, there is a reasonable steps defence which an employer can pursue if they've done everything that is possible and reasonable to prevent such acts from occurring. And that relates partly to training and awareness sessions for the employee, but also the commitment to investigating grievances. And if it's found that the employer has not progressed an investigation once an employee has raised those complaints, they may not have the reasonable steps defence in any future discrimination or harassment complaint. Now, whilst the employee themselves may be criticised for not pursuing a grievance or asking that it isn't investigated, it doesn't stop them from bringing a discrimination or harassment complaint. And in the context of the employer's defence, it doesn't look very good if the employer says that they took no action on receipt of those complaints. We also have to consider the implied duty of trust and confidence. So the employee who has raised the complaints themselves, if the treatment gets any worse, could try and found a constructive dismissal complaint, but also other colleagues who may be at risk as well. So if we've got concerns raised by an employee about widespread bullying by a colleague, if a separate employee brings a constructive dismissal argument and realises that no action has been taken for a similar complaint, that could also assist their claim as well. Now, in the context of harassment specifically, the Equality and Human Rights Commission have prepared some advice which states that even where an employee asks not to take the matter any further, the employer should still take steps to ensure that it's resolved. So a record should be kept of the complaint, the employee should be encouraged to address the issue, the employee should be given necessary support and guidance, the situation should be kept under review. And ultimately, if the matter can't be resolved informally, the employee should be told that it's necessary to address the issue for both their well-being and that of their colleagues. The employer should take into account the wishes of the employee, because not doing so could compound the harm caused by the original conduct. And that's something the employer will always have in their mind. If I do pursue this investigation, what harm is going to be caused by the employee who did confide in me and did give me their trust by telling me these issues. But the risk of not taking action will often outweigh that. And in the circumstances, we have to look at appropriate safeguards for the employee, communicating with them and making it clear why we believe we need to act in these circumstances. The other issue, of course, is that if there is wrongdoing, the employer will often want to stamp it out. So if there are genuine allegations of bullying, harassment, discrimination ongoing, if an employee has given us substantive information on that basis, aside from wanting to protect ourselves from claims, we will generally feel that we have a duty to investigate and try and stamp out that behaviour. And that's why all of those factors go into the mix when deciding whether to act if you do receive some confidential allegations that the employee doesn't want to be taken any further. So I hope that's given you some good insight on reluctant witnesses, reluctant complainants. If you do need any further advice on this, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.